The matter before the court is Clegg versus American Airlines. This is Cumberland 24-101. I see counsel are present. We are being streamed live on the web by both video and audio. And if counsel would please introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good afternoon, Your Honor. My name is Bals. I represent the appellants, Campbell, Clegg, and Clegg.
Good afternoon. My name is Bill Smart. I represent the appellee, American Airlines.
Thank you. And Mr. Bals, if you're ready to proceed, we'd be happy to hear your arguments.
Thank you, Your Honor. May it please the court. My clients are appealing this case, the order of summary judgment, because the Superior Court erred in its conclusion that their claims were preempted by the Airlines Deregulation Act. And let me say at the outset, I recognize that the scope of federal preemption is exceedingly broad. There's no question about that. I concede that. And everyone agrees, I believe, in this case, that the test is whether the cause of action asserted is predicated on a law, regulation, or other provision having the force and effect of law, and if the claims are sufficiently related to an airline's prices, their routes, their services, such that preemption would be warranted. Simply put, do the claims at issue in this case regulate the airline's operation? And the answer in this case is the claims do not. The breach of contract claim that's asserted in this case does not relate to prices set by an airline. It doesn't relate to routes established by an airline. It doesn't relate to rates established by an airline. The Superior Court appeared to feel that the claim for breach of contract was premised on a failure to issue a boarding pass and that was regulatory. And there is no dispute in this case that as a factual matter, and I think this is exceedingly important for the court in this case, as a factual matter, no one knows why it is that the Cleggs were not permitted to board the airplane. There's not a reason given. It's simply an unknown. And everyone concedes that there were seats ready and waiting for them, and that those seats were...
So why isn't this related to an airline's services, that they don't give you a boarding pass when you should get one?
Because it would relate to the services, I believe, Your Honor, if in boarding there was some policy that the airline had, and I can see...
But why does it matter why they may or may not have given you a boarding pass? It's still a service that's a part of the flight experience, isn't it?
I don't think it's a service when you just say, we're not going to let you on the plane.
Well, it's not providing the service, but that's still related to a service.
I think it would be related. I think an airline has every right to say to me, you can't get on a plane and board if you're carrying something that looks like a weapon, or you're bringing a cheetah on board.
Well, you're looking at the merits now, beyond preemption.
I think that preemption does not cover having no basis whatsoever to honor a contract. That's what I'm suggesting to this court.
So then are you limited to contract remedies? In other words, a breach of the COC, of the...
I think there's other claims asserted here, Your Honor, and I don't think those necessarily go to the boarding or the refund, because the court may recall, as a factual matter, it went beyond simply saying, we're not going to let you on the plane. Then there was here's how, we're going to tell you how you can rebook and we'll honor that flight, and that was all incorrect also. In other words, they said, we can't rebook for you, then this is in the record.
That's really the nub of the matter, isn't it? You want more than a refund of the flight ticket, which may be all that you might be entitled to under the conditions of carriage.
It may be, Your Honor. I will say to the court, I think there's some significant consequential damages that aren't in the record, because that wasn't an issue for the summary judgment. But you're correct, fundamentally. There are other types of damages that would flow from other causes of action. I think that claim is certainly has merit. That is to say, you misrepresented the circumstances under which I need to book a new flight. But the primary argument here is, and I am concerned by what the court said, but again, I think any reason you want to put out there for why we're not going to let you on a plane when the seats are right there, everybody can see, that's probably going to get preempted. But just to blanket say, we're not going to honor a contract, period, for no reason whatsoever, which is essentially what this case is. It's as if you bought an airline ticket and can't get on.
Does that mean your recourse would be a refund?
It may be a refund, it may be more. I mean, that's a damage question, but I mean, I think there are certainly damages that flow from a breach of contract.
Well, there was a reason. The reason was they couldn't locate them in the computer system, right?
Well, there's been no refund made in this case. So there hasn't been a refund.
Is there recourse, other recourse besides a state law contract action?
Well,
Is there arbitration, or is there something in the conditions of carriage which provide a pathway for a remedy?
I think the remedy is, no. I mean, I don't think there's an arbitration provision, so we weren't bound by arbitration.
Well, the language of the conditions say, if we refuse you to fly for reasons other than your violation of contract, we will refund you. So doesn't that mean your only remedy is a refund?
Well, I mean, it may. I mean, a refund is certainly out there, but I mean, I think we're outside the scope of the federal law now by basically saying we're not going to honor this flight at all. There are significant consequential damages.
But that's the same thing as if we refuse you to fly for reasons other than your violation. We didn't have a good reason to do it, you get a refund.
I mean, I think you could argue that that a refund is out there, but that's not, I mean, that is not something that's been tendered, or at least as part of the case.
So you'd be happy if we said, well, it's not preempted, but all you get is a refund?
No, I would not be happy with that, because I think we can go beyond that in these circumstances for traditional contract damages. All of the damages that would normally flow from a breach of contract.
Well, not if you had a contract that said your remedy is only a refund, which is essentially what this condition of carriage says.
I mean, isn't the condition of carriage the contract?
I think in part, yes.
So even if this was under Maine law, you'd still only get the refund.
I think that I think there's an argument for certain consequential damages that would flow in addition to the refund, Your Honor.
But only if the airline agreed to be liable. Isn't the whole preemption doctrine pretty clear that the airlines are not liable for state-imposed damages except to the extent they have agreed to be in the conditions of carriage, presumably?
I mean, that's the argument on preemption, yes. I mean, again, I don't think this is a preempted claim. I do not. I mean, our position out of the gate is this claim is not preempted because it doesn't fall within the category of claims that are normally preempted. Again, we're not, the remedy here, we think, is a breach of contract claim, which is not attempting in any way to regulate the industry.
But are breach of contract claims preempted, but for the conditions, the actual contract, the conditions of carriage in this case?
I mean, they breached the contract. I mean, I think that's, from our position, that's clear. So I would argue that what flows from that breach of contract are all contract damages. I don't think that they are necessarily liable just for the refund. The refund is definitely there. I agree with the court there. I'm just not prepared to concede that there aren't more damages that flow from the breach of contract.
So you're suggesting it's a breach of contract action that you're entitled to consequential damages despite the fact that the contract by its terms would appear to limit it to the amount of the ticket.
That's true, but there are also the other claims also, Your Honor. I mean, there's a fraud claim that's been asserted here, and we think we are entitled to fraud damages on that. And the fraud, again, is telling, I mean, I think this is undisputed in the record, is the representations that if you book another flight, you have to do it yourself. We'll honor your return flight on this, and that was not done.
So what we're really arguing about is whether there is at least a question of fact in this case?
There is well, I'm not
Because, I
sure
mean,
there's
it
a
was-
question of fact in terms of their breaching the agreement, because I don't know what that fact would be.
Well, I'm
They-
not sure they've conceded it, so I'm leaving it at that, but.
Fair enough, Your Honor, but I mean, they say, I believe, and if I'm misquoting their brief, but I think it's always been conceded, we don't know why we wouldn't let you on that plane. The seats were there. Everyone agrees.
So at the point where they asked, I mean, has your client asked for the refund and they refused because was there a reason they gave for why they refused?
There's been some settlement
No,
negotiations in this, Your Honor?
before that, before you sued them.
Oh, I'm not aware of that. I guess, in fairness to Your Honor, I'm not sure, Your Honor. I don't know.
So we don't know whether they asked for the refund or whether before litigation began,
But it doesn't matter, because at this stage, your client wouldn't have been satisfied with simply a refund in any event.
Well, and on the damage question that you raise, I guess I should have stressed earlier, in addition to the contract damages, and maybe there's a limit there under the contract of carriage, we have these other theories that,
if they aren't preempted.
if they aren't preempted. I mean, that's true. For example, you represented to me, here's what I shouldn't do, we're not going to book it for you, you do it, you'll be okay. That wasn't okay. So I don't think that's preempted again, because I don't see how that type of claim is in any way trying to regulate how the airline
Well,
operates.
it's not really trying to regulate, it's relating to, isn't it? Isn't that the language?
I think that is part of the language, Your Honor, but let me just say, I don't think that our claim is you just didn't do anything for no good reason. You didn't let us on that plane. And I don't think that type of claim is related to their operation. It's just not honoring a contract.
I don't necessarily disagree with that, but the fraud claim you mentioned is related to their operations because it gets at their policy in terms of rebooking and what they say to people in terms of rebooking. Isn't that different than the bottom line? We had a contract to fly, we weren't allowed to fly, and it wasn't our fault.
Well, it may be. I'm just not sure that all the representations that were made at that ticket kiosk, Your Honor, were following the manual, so-called, that's a matter of policy.
So if any agent ever gives bad information to someone who's flying, you've got a fraud claim?
No, I don't think you have one in every instance, Your
So
Honor.
why did this go past the line? What makes this different?
Because I think you have to look at the specific facts. It stems from, first of all, again, for no good reason at all, saying you can't get on a plane, we acknowledge your seats are there, and you have to, I think, consider the fraud in the context of that. We're not going to let you board, we're not going to honor your ticket, and then if you want to get a different flight, trust us, you book it yourself and we'll honor your return flight, which they didn't do.
That's their policy, apparently.
I don't know that that's a policy. I mean, if it's, I don't know that it's a, if it's a policy, it's a weird one, because, I mean, why would you suggest I'm going to do that and then not honor it? And there was no question that they didn't honor it. So, I think you have, in terms of the damages, which you have not only the contractual damages and possibly the limitation in the contract of carriage, but you have these other claims that stem from denying this. And again, it's not just we don't think we should let you on the plane and here's some reason, even if it's not a good one. There's just no reason at all, and that's a breach, which I think has been conceded.
Thank you.
Thank you, Your Honor.
And Mr. Smart.
Thank you. May it please the court. This is a case where the appellants arrived at an airport in Albany later than recommended, even though they knew that there was some problem with their reservation because they weren't able to check in for their flight online. There was only about 15 or 20 minutes before the bag check cutoff deadline to resolve this issue. Boarding passes need to be issued, bags need to be checked within 45 minutes of takeoff. Unfortunately, that could not be accomplished. There were alternative flights discussed with the Cleggs that were not acceptable to them, and they chose to go book with another airline and to fly out of, in fact, a completely different airport to get where they were going. The legal issue on appeal, of course, is whether the Clegg's claims are federally preempted by the ADA, which is an important federal law that's been on the books for several decades, and is really designed to promote the benefits of competition in terms of rates, the services that airlines provide, the routes that are traveled. And it's through that competitive process that Congress felt that services would improve, for instance, rather than different states regulating the way things ought to be. Under the ADA, the states are forbidden to enact any law, rule, regulation, policy, et cetera, with the force and effect of law that relates to airline prices, routes, or services. Obviously, services is the key issue in this appeal, and whether a related to services claim is preempted, I would submit, involves perhaps 3 separate questions. The first being, do the plaintiff's claims or the appellant's claims take issue with some customer-facing activity of the airline or function of the airline? Is it something customer-facing that they're complaining about? Is it the type of things that airlines compete over with each other? And would enforcement of the plaintiff's claims impose some obligation on the airline? Or in other words, would enforcement have that forbidden regulatory impact by putting obligations, state law obligations, upon the airlines? The answer to all 3 of those questions is clearly yes, and for all the reasons that we outlined in our brief. The so-called Wallins exception is really just a corollary of that third question.
Green light's on, so I want to make sure I understand your position. When somebody comes up to check in and assume that they've done nothing wrong, and they say, I want to check in, are you saying that it's okay if it's preempted and there's no recompense and you don't get a refund if there's a good reason not to let them check in? What happens if the agent says, I don't want to check you in? Is that a violation of the conditions of carriage, so you're allowed to get your refund and only a refund? I mean, they've alleged I went up to the check-in, I did everything right, they gave me no good reason why I could check in. Are you saying you're entitled to nothing, or you're entitled to your refund?
I'm saying that they're legally entitled to nothing in this particular case.
So why?
Because as on the facts, or because no matter what reason you decline to check them in, they can never get a refund?
On the facts, I think.
Okay,
I think
but then isn't that a factual question? I mean, what you're suggesting is, I mean, this is in front of us on summary judgment, saying that there's no factual question. So back that up. I mean, you agree that under the Wallins exception to the exemption, to the preemption, that if, and I understand you don't agree the if, but if there is a claim for breach of contract under the conditions of carriage, that is not preempted, correct?
Correct. If there's some clear violation of the
Okay.
express terms of the contract.
So under the conditions of carriage, do you agree that they are in fact due a refund if you refuse to let them fly for reasons other than their violation of the contract?
For that and other reasons in the contract, there is an entitlement to a refund.
Okay. So I know that you're suggesting, well, they really got there too late, they knew there was going to be a problem. I mean, isn't that a fact question? How late is too late? It's not an absolute of when they had to be there. You recommend that they be there earlier, but they were there as it's presented. Maybe it would not turn out to be the case, but as it's presented, they were there in time. And you didn't give them a boarding pass.
Well, I would submit it's undisputed that they were not there in time, because we had, say, 15 or 20 minutes to resolve this issue.
Well, there's nothing in the contract that says it has to be more than 15 minutes in advance.
Well, the contract says that they recommend arrival at least 2 hours in advance.
That's a recommendation, isn't it?
It's linked to the conditions of carriage, I would submit, for one thing.
Is the airline maintaining that the reason why they didn't fly is because they arrived at the airport late?
Yes, in the sense that there were issues checking them in that could not be resolved within the
I
available
guess
time.
I'm just not understanding how that's not all at least a fact question. I'm not saying you automatically lose, but I don't understand how that's not a fact question to be resolved by a jury or by the fact finder.
Well, I mean, I think that I think there are undisputed material facts that were before the trial court, establishing the time that they arrived, what they say
Suppose
occurred.
they arrived on time. And I don't know, we're talking about, what, 15 minutes here? Suppose they arrived exactly on time, and this problem was still not able to be resolved.
Well, I think the recommendation was that they arrive within 2 hours of takeoff. They arrive perhaps as little as 1 hour, a little over 1 hour.
I don't know
but let's
about you,
assume-
but it's never taken me more than 15 minutes actually at the desk to check in.
Let's assume they arrived on time. What's their recourse here?
Well, I mean, I think their recourse is within the terms of the conditions of carriage. It's complaints to the Department of Transportation, and I think it's also to just, with your feet, go fly on another airline, because Congress.
Is there a dispute mechanism set up in the Department of Transportation? In other words, what does a customer do when this happens and they believe that they are entitled to a refund under the conditions of carriage? Where do they go? What do they do?
Well, they contact American Airlines. There is a dispute resolution process within American Airlines. I don't feel comfortable speaking as to the Department of Transportation's policies. I know
Well, you
they are
didn't
the
argue
ultimate.
that they didn't exhaust their remedies with you. And I think I heard you saying that if you hadn't had a good reason, then they would be entitled to a refund under the conditions of carriage, and so it would be okay to have this lawsuit and get a refund as the result of the lawsuit. Is that correct?
I would say, if there's something expressed in the conditions of carriage that say, we did not give you a boarding pass, as it does, for reasons that are not.
Well, it does say that. It says if there's no good reason, then you get a refund. So I'm understanding you saying that if the facts turned out there was no good reason, then yes, they could file for breach, for breaching the conditions, and they would be entitled to an award of their refund, correct?
Correct.
And it's your position that on these facts, if I'm understanding you, then in fact the plaintiffs did violate the contract because they got there too late.
Correct. There was a recommendation that they arrive.
Well, is it your position then that under this contract, unless you present yourself at the desk more than 2 hours in advance, then it doesn't matter? They're in violation of the contract?
Well, our position is that if you don't present yourself to the airport 2 hours in advance, then you're running the risk of not being able to get through and receive a boarding pass within the time frames that are provided, which is 45 minutes from takeoff. You're running that risk, and that's not attributable to the
And if they don't make it to the desk because they aren't there in time, that would not be necessarily you, quote, refusing to let you fly. But if they're at the desk, you're saying they have to be at the desk more than 2 hours in advance?
No, the
contract
recommendation is
doesn't
to arrive at the airport at least 2 hours in advance. You could certainly imagine a situation where there's just an extremely long line at check-in, and they're unable to get a boarding pass. That could be for many reasons. It could be poor staffing.
And that's the reason for the recommendation that you arrive that much in advance.
Of course.
But that's not what the contract, it's a recommendation. And the absolute is 45 minutes, and the facts that were presented is that they were there more than 45 minutes in advance.
Put in
the contract-
contract terms, isn't the issue whether their late arrival was a material breach? Isn't that really the contract issue?
I think the issue is that the conditions of carriage say, they don't even say that we're required they say that you have to be checked in within more than 45 minutes from your departure. They don't say anything about how long it's supposed to take us to check you in, and it doesn't guarantee that there won't be issues that occur, at the airport.
So that's why it may be an issue of fact as to whether you violated the contract. But you're really defending on the basis that they violated the contract, therefore, as a matter of law, you don't even owe them that refund.
Well, I mean, I'm defending on the basis that they made multiple claims here, which we feel are federally preempted.
Well, in fact, in the red brief, I think you said, well, the airline's not contractually obligated to provide boarding passes at all.
It's not in the conditions of carriage.
I also don't understand boarding procedures, ticketing, baggage handling. Don't those fall under the preemption? Are we talking about boarding procedures here? And
Absolutely.
If so, isn't that preempted?
Absolutely, absolutely. And so what we're really talking about is this very narrow exception in Wallins, and it is so narrow because it's a very slippery slope.
Well, in enforcing the actual terms of the condition
Right.
of carriage.
And that's what I'm trying to talk about a little bit, is not beyond the conditions of contract, but just whether there's a fact question under the conditions of contract.
So you really, I'm trying to understand why you're taking the position that they weren't entitled to a refund.
As a matter of law.
Yeah.
Well, all I can say is that the conditions of carriage, they provide what they provide. They say if you're entitled to a refund, if we don't issue a pass for reasons that are not,
Right,
our fault.
right.
I understand the point that the court's making about the
Just a
record
recommendation.
below.
Yes.
Well, it is linked to the conditions of carriage, and I think the question is, are we obligated to issue a boarding pass? It doesn't say that in the conditions of carriage.
Do we have any other way of getting on flights other than having the airline issue a boarding pass?
No.
Is there anything in the record that if they had come an hour earlier, that the snafu would have been fixed? Were they still working on it, or what was going on?
Yeah, I think that's true. I mean, I think they were still working on it until it got to a point where it was clear they were not going to make that flight, and then the conversation turned to what else can we do for you?
So one agent would spend 2 hours trying to fix it, and the problem is they didn't come 2 hours ahead of time.
Well, I mean, we don't, because they didn't come, we don't know how long it would have taken to get that resolved and whether it would have been resolved. I mean, we weren't given the opportunity to resolve it within the time period that would have allowed them to check bags and get on the plane.
There don't appear to be additional questions. Thank you.
Okay, thank you.
And Mr. Bals, I believe you reserved 2 minutes for rebuttal.
I did, Your Honor. Thank you. On the factual issue, obviously, to the extent that the court believes there's a factual issue, it should be remanded for resolution of that factual issue. I mean, when I look at the Appendix 10, and that's the lower court's decision, first of all, I thought there was somewhere that there was a provision you should be at the airport, as part of the contract an hour before. I think there's a recommendation, try to get there before 2 hours before. What the trial justice held or found as a factual matter was the Cleggs arrived at the airport at 4:47 on May 14, reached the ticket counter sometime before 5 a.m. The flight was scheduled to depart at 6:04 on May 14. So the finding was you're there within that hour window, and I mean, maybe there's a recommendation you be there 2 hours before. I don't think it would have made a difference. I don't think this is in the record, but 2 hours before would mean we're talking, is your ticket counter going to be opened at 4 in the morning? And I'm not even sure that would be true.
Well, I mean, if the ticket thing isn't open, so you couldn't possibly do it, then you win on the facts. But
Right.
that's not in the summary judgment record, right?
No, but what is, it's true. But what is in the record is a finding that we were there an hour there, clear of
But
an hour.
he's saying you should have been there 2 hours, which I understand is a little strange if you have a 6 o'clock flight and the airport isn't open yet.
It makes it difficult to board, for sure, Your Honor. So I do think that's a problem, but again, that is the recommendation. I don't think that was mandatory or binding, and I don't think there's any evidence in the record it would have made any difference. They were there an hour before, those seats were there, their companions are flying, they're seeing the
Well,
empty
but you
seats
don't
all the
know
way
if
to...
it would have made any difference. Maybe they could have fixed the computer glitch, right?
If it was a computer glitch. I mean, through discovery, we still don't know why it is they weren't allowed to take those seats, which were conceded to be there. So for all those reasons, I think that this court should reverse the decision of the trial court as to all three claims, including the unfair trade practice claim. Thank you.
Thank you, counsel. We will, as is our usual practice, take the matter under advisement and issue a written decision in due course. It is also our usual practice and custom